Previously on X-Men.
Yeah. All right, let's take 10 minutes and then we'll see where we are then. See where the day leads us. All right?
I got a headache.
We'll be in recess 10 minutes.
I might take the fifth.
Excuse me, Your Honor, may I bring something up before Mr. Copeland comes in?
Go ahead.
I believe I heard him say on an open mic yesterday, gave his testimony that he may take the fifth today. Can you inquire into that prior to the jury coming out?
I didn't hear him say that, but I can.
Thank you, Your Honor. Your Honor, also...
Pieces of business I have to do, at least for the record. Renew our motion for a mistrial.
Denied. Okay,
Thank
what
you.
else?
And also, again, requesting for the purposes of cross-examination, the transcripts from yesterday.
I'm deferring on that one for the time being, okay?
Thank you.
All right. Can we, do you have something, madam?
Yes, Your Honor. I just wanted to say for the record that that is not his position. He explained yesterday, I believe that he had...
You talking about he being Mr. Copeland?
Yes. What he said, and I was standing there when he said it, was that his head hurt, and if y'all don't let me go,
Is this at the end of the day?
Yes, at the very end of the day. He did not state without qualification, I'm going to plead the fifth. He said, if y'all don't let me go, I'm about to plead the fifth again. That's all he said. Ms. Hilton has been speaking with him. He has given her no indication that that is his intent.
We'll find out. I will find out before the jury comes in.
I might take the fifth.
The published once it's submitted with the court's ruling.
All right. Where is he?
He should be on his way there.
Mr. Copeland, again, good morning, sir, and you're still under oath, okay? Yes?
Okay.
Okay. All right. Sir, is it your intent to continue to testify today, sir?
Yes.
Okay. All right. Summon our jurors, please.
You know, if that was another lawyer like the old man that he was yelling at the other day on Friday, when he was going off on him like, you should have told me, why didn't he get on Miss Love and Miss Hilton? Why didn't he get on them about it? I got you. Let's get into it.
Before we call in our jury, it has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpus, would like to be released. Is that correct, madam? Yes, sir. Okay, all right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She's fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right now.
I don't want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
What I need a lawyer for?
Hmm?
What
No, it's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Bumpus, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you've given oral notice, but usually it has to be in writing, and he has 10 days to object.
Well, Judge, just for the record, I was never his counsel.
Say again?
I was never his counsel. Attorney Glanville was his counsel, and I was stepping in as a courtesy for judicial efficiency. I was motion to withdraw.
Well, given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
I'll get that done now, Judge.
Okay, all right. And he's got 10 days to go ahead and do that. So you're still going to have to be here until because he gets that particular period of time to go ahead and decide whether or not he'd like to hire a lawyer. That's the whole reason for the 10 days.
Well, I don't want to hire no.
Hold on. Not yet. You get that right as a party. Okay.
I do get right.
You do. Yes. You get that right to hire a new lawyer. You get the right to do a couple things. One, to decide whether or not you can release her.
Okay.
Okay. Two, you get to decide whether or not you want to get another lawyer to be with you.
Okay.
Okay. Those are the two big things you get a chance to kind of decide. But what I'm going to do at this point in time is, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw. But you're on the stand. You're testifying at this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. So, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation with you and Mr. Melnick and whatever, but, Mr. Copeland does have rights in this particular circumstance. So file a proper notice to withdraw. I'll give once it's filed, if you file it today, I'll give Mr. Copeland the 10 days. But until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
Okay, Judge.
Okay. Madam, I have one other bit of business.
Also, can we approach? Can I approach, Your Honor, with the state?
No. What does he want to tell me?
I don't want to say it in open court.
Do you know someone by the name of Jeffrey Williams?
I heard of him. He's a rapper.
Okay. Do you know?
I know him. I don't know him as Jeffrey Williams. I know him as Young Thug.
All right. And when you say you know him as a rapper, have you ever spent time with this individual?
Yeah, I did.
Okay. When is the first time you recall? Strike that. What do you refer to him as?
Young Thug.
Okay. When's the first time that you recall meeting Young Thug?
At the studio.
And roughly, what year are we talking about?
Before I went to jail.
Which time?
Right. Before that, I went to the feds.
So before 2015. Do you see him in the courtroom today?
Yeah.
Can you identify him by article of clothing he is wearing?
Brown. With dread, sitting next to the bald head guy.
All right. Is anyone else on the other side of him?
We'll stipulate Ms. Williams to sit next to him.
Okay. All right.
Thank you. You said that you met at the studio. How did you meet him at the studio?
Through a friend.
What friend?
I really didn't meet him. I just saw him at the studio when I was with a friend.
What friend were you with?
And I asked him, can I take a picture?
What friend were you with when you saw him at the studio?
Doc.
Was it anyone else?
Huh?
Was there anyone else?
There's a lot of people there. I don't recall who all the people was.
Do you recall if Tick was present when you first met Miss Young Thug?
I can't recall.
You said that you met him at the studio and you asked to take a picture with him. You're right, I'm looping the question so I can get to my next question. When you met him at the studio and you took a picture, did your friendship or relationship develop after that time that you met him in the studio?
What you mean?
Did you all develop a friendship?
Did we develop a friendship?
Yes.
My definition of a friendship is not just knowing somebody or knowing who somebody is.
Okay. Did you start hanging out with him?
I started going to the studio a lot.
Okay. Did you start hanging with him outside of the studio?
I have.
Okay. When you hung with him outside the studio, where type of places would you hang out with him at?
But most of the time, he liked to be in the studio.
Okay. My question is, when he was not in the studio and you hung out with him, where would you hang out with him at?
We used to do fun stuff, like go to like bowling alleys and stuff like that. He went to the kids' football game, I remember. I've been to the club with them. I've been on shows, I mean, correct that.
You said on shows?
Yeah, like when I watch him perform.
All right. And is this, the shows, the bowling alleys, the club, are we talking about in 2014, 2015, or some other time?
2014 only.
2014 only. In 2014, about how often would you see each other on a monthly basis?
I don't keep up with that type of stuff.
Okay. Did you see him a lot in 2014? Was it quite often? Were you always around? Or did you see him once in a blue moon?
Well, to know that he was a rapper and successful, I seen him a lot. To me, I think I saw him a lot.
Are you referencing like seeing him on television or being around him in person?
What you mean?
You just said, because he's a rapper, I saw him a lot.
Yeah, because you don't see rappers a lot. So,
and I'm sorry, I just want to clarify. When you're talking about seeing him, are you talking about physically being in his presence or seeing him like on television?
I knew people that be around him.
Okay.
And I used to see him a lot. Every time I see him, I saw him.
All right.
I was happy to see him.
Besides seeing him in person, would you ever speak with him over the phone?
Meaning?
Did you ever talk to him? Let's first start old school. Pick up the phone, dial some numbers. Would you ever talk to him over the phone?
Have me and him had conversations?
Yes.
I can't recall if we did or didn't.
Okay. Let me ask you FaceTime. Have you and Mr. Williams ever FaceTime with each other?
I can't recall.
I can't recall. Let me just ask you generally, in 2014, with any of your friends, Shannon, Little D, Yak, or you said you didn't speak to Yak, would you FaceTime any of them?
Say that again?
Shannon and Little D, would you FaceTime them back in 2014?
I don't like FaceTime.
I know you don't like it. That's not my question.
You know what I'm saying? So most of the time I talk on the phone, I call regular.
Okay, but have you?
I don't recall talking on FaceTime.
You don't recall talking on FaceTime?
Not that I know of. Not that I know of. And I don't. You had to ask that again because I ain't for sure what you're asking.
Sure. I'll ask you again. 2014, 2015. Have you ever? I'll wait till you finish.
I'm tired.
You and I both. Okay.
I sustain the objection.
Back in 2014, have you ever FaceTimed with Little D? Ever? Back then?
Little D?
Little D.
How I supposed to remember that?
Do you recall ever FaceTiming with Little D?
I don't.
Okay. What about Shannon?
I don't.
Okay. What about the person you identify as Young Thug?
The person I identify as who?
Young Thug.
I don't.
Okay. What about, you said noted yet?
If I FaceTime with him, I probably screenshot it and post it on social media just to show people that I probably was on the phone, but I don't remember if I ever did have it.
Okay. Now, you said that you would spend time with him, whether it's a studio or in other places. Were you close to Young Thug as you were Shannon and Little D?
That's not established under a foundation.
I sustain the objection.
Did you speak often with Young Thug back in 2014? Did you talk to him often?
Not that I recall.
Not that you recall.
Hey, yo, you. Can you subscribe and turn on that bell too? Because when you do, you're helping unbiased, independent news. The Georgia versus Khalif Adams, etc. defendants. Order to show cause. The court having been presented with an issue of contempt for determination, all individuals that were present for the ex parte conversation that took place in the court's chambers on the morning of June 10, 2024, to include witness Mr. Kenneth Copeland, his attorney, Ms. Kayla Bumpus, and all representatives of the state and court security personnel that were in attendance are hereby ordered to show cause before the Honorable Euro Judge Glanville on 25th day of June 24th at 9 a.m. in Courtroom 1C, 185 Central Avenue, Southwest Atlanta, Georgia, 3030. Why one or more of them should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel. It is further ordered that the failure of any of the individuals who were present for the June 10, 2024 ex parte conversation will cause the court to direct the Fulton County Sheriff's Office to take them into custody and bring them to the bar of this court. So ordered on this 11th day of June 2024. God damn. So here's Rule 2.9, ensuring fair hearings and averting ex parte communications. Judge shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties of their lawyers concerning a pending proceeding or impending matters subject to the following exemptions. Where circumstances require ex parte communications are authorized for scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits, provided that a judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a part of the ex parte communication, and the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And that's where we have a problem. Here's where it gets interesting. Shout out to Andrew F. He's an Atlanta-based attorney. He says, let's go through some relevant law. First off, judges are not supposed to talk to parties without opposing counsel present, except in a few limited circumstances, which we already went over before we got to here. Here's Uniform Superior Court Rule 4.1. Rule for attorneys' appearance, withdrawal, and duties. Rule 4.1. Prohibition on ex parte communications, except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties of their attorneys concerning a pending or impending proceeding. He says, I'm not aware of any rule that permits a judge to meet ex parte with the witness. Well, we already showed that. There are some similar things that a judge may do. For instance, when the state wants a material witness warrant for an absent witness, a judge may grant that without notifying the defense since they lack standing to object. But take it from one party present, not notifying anyone else, and having a conversation with the potential witness about whether he would testify seems far beyond that. At a minimum, Glanville can't hear the recusal motion. If a recusal motion is heard, then the sort of denials that Glanville has been making, in which he inquires instead about how the defense attorneys found out about the communication, can be an independent basis for recusal. As whether Steele can be put in contempt for refusing to answer the judge's question, I am dubious. Johnson defense counsel was actually handed a notebook that contained his client's emails, which the state had not disclosed to him. It came from the judge. So when defense counsel was hesitant about handing it to him, the judge put him in summary contempt and then ignored subsequent recusal motions. Here, while still argued that the communication was confidential under Rule 1.6, he was repeatedly interrupted by the judge and may not have been given a full opportunity to explain why he should not be held in contempt. Also, anything you learn through representation is confidential, and you cannot be compelled to reveal it except through a court order. I'm not sure that the judge simply telling Steele to tell him the source was a proper court order or whether he needed a subpoena. Brian still has some excellent lawyers working on his behalf, and I'm confident they will find better authority than I dug up. It is also worth pointing out that whatever was said to this witness in chambers is, of course, relevant and admissible at trial, may always be proved is strong language. He's talking about this. Georgia Code 24-6-622. The state of a witness' feelings towards the parties and witness relationships to the parties may always be proved for the consideration of the jury. In the most sympathetic possible reading, there was a threat to the witness, and he wanted reassurance that he'd be safe, but defense counsel still gets to hear that. If the threat keeps the witness from testifying, state can claim defendant forfeited right to cross. This totally secret ex parte meeting is not like anything I've ever heard before, and I couldn't find a case on point with it in my limited research. Truly strange. And he said, anyway, here's the contempt statute, OCGA 15-1-4. For the second record, yes, you can appeal from a summary of contempt. The judge admitted that he had an ex parte meeting. So what the hell? And then, bruh, shout out to the visionaries for sending me this clip right here. And this is why the hood lawyer is good at what he does. And shout out to the visionaries who were shooting me all type of laws and stuff like that and everything. It took a lot to get down to where we're at, but I did put that opposing view right there. And I'm going to be honest with you, I don't think the judge was in the wrong. I know some people will be like, see, Sandy Nash, you're supposed to be this person. Bruh, if the judge didn't feel that it was a tactical advantage for the defense and everything like that, then bruh, we gonna see. But on the other hand, playing devil's advocate, that judge like, hey, I want everybody to pop up on the 25th, and we gonna go ahead and depose y'all, and we gonna find out who did what. That's gonna be wild, bruh. I gotta get my popcorn ready for that one, bruh. Either way it go, man, so far from what it looks like the judge didn't do anything wrong. But one thing it didn't say was the timing of letting the defense know. So that's the thing. We never see it in the actual law when the judge had to let them know. And that's a little oddball behavior right there. But if I'm still, and I'm regular on Nash, I'm still saying, bruh, how did he go from pleading the fifth to now I want to cooperate and communicate and all that stuff like that and everything? Because, bruh, something happened. Something was said or anything like that. And then for still to holler out what he hollered out, that was where I kind of was like, bro, why would you say that? So when I initially said what I said last night, bruh, Woody could have been like, man, I fear for my family and stuff like that. And, you know, it may seem like it's going to allude that I killed Big Nut. I don't think Woody killed Big Nut. Now, some people do, some people don't. That's on them to prove and stuff like that. I can really be persuaded if the evidence shows that he did it, or he flat out come out and say, I did it. I don't think he will, because even if the state gives you immunity, the feds can still pick that up and charge you on federal murder counts and stuff like that too. So there's that part. So I don't think he's going to be coming out and saying I killed Donovan Thomas at all. It just, to me, it doesn't make sense from a legal standpoint, because we got to understand, your mama may say, that's the state, oh, it's all right, baby, tell me everything and you won't get in trouble. But that don't mean your daddy won't say, hey, all right, I'm finna beat your ass. So that's how I see it as. Woody firing his lawyer? That was odd. She was cute as hell. Man, Atlanta got some gorgeous ass lawyers, bruh. Whew. I'm just gonna tell you, if Sandy Nash became the hood lawyer, I'm probably going, nah, I'm playing. Let me stop playing. I'm just joking. They just got some gorgeous women, and it's dope to see. Either way it go, bro. Woody firing his lawyer, I don't know what type of advantage that really gave him, because he didn't necessarily fire his other lawyer. He just didn't like the one he had. Now, is she a little ratchet, a little ghetto? I have no idea. But did she come off that way a little bit? Just a tad bit. But so what? You need a little spice in life. If it ain't seasoned, you ain't sneezing. If you ain't sneezing, it ain't seasoned type of ordeal. But you don't really want that in your... Let me stop doing this shit. All right, so, long story short, what happened today in court? What were we seeing in the first half? Basically, what the state is trying to prove in the early inception is that Woody ain't some Randall who came and hung around and all of that stuff, that he actually knows all these people. He's been cool with these guys for a minute, and he has connections and friendships with these people, so that Woody isn't some guy who just so happened to be some guy off the street. So for y'all saying this is boring and all that stuff, and where's the fireworks? Those are going to be the fireworks for a minute. I think it is very possible that Woody going to be on that stand for damn near 2 weeks. And the judge, if he fails, I think he's going to be pressured into basically stepping away. Like I told you, I told y'all this 2 days ago. I'm like, bro, I think the judge going to end up saying, you know what, bro, I'm going to go ahead and get on out of here. Because after yesterday, man, everybody seems defeated. And I'm going to give Brian Still an A+ because it couldn't have been me. I would have came in there so disrespectful. I would have got, and I know y'all going to say, well, bro, Thug is paying him millions of dollars and he's got to have professional decorum. He is a lawyer and he could have just gave up his source and stuff like that. I get all of that, but the petty in me just ain't gonna let it live. I would have had to say something, bro. I ain't gonna hold. I gotta say something, nigga. You not just finna throw me in jail and I ain't gonna flame your ass or something like that. So we'll see, man. I do believe that the judge is going to essentially have his ruling, but not like how he wants to. Bro, you can't be the judge on your own cases and stuff like that. And like I said, they sent it up to the appellate courts. So we'll see how all that stuff goes. But from what it looks like, the judge may be able to skate on this one. And if you want to know why the judge will not be granting a mistrial, I'll pin it in the comments. I did the story of Judge Euro Glanville, and I have a reason why I don't believe that he'll do it. Or if you want in the description, you can check out the dark side of a lady who let a kid with mental disabilities die off, and that was Miss Love. Whichever video you want, or you can choose the video that can exonerate a man from a murder that he did not do. But subscribe to that bell, stay notified. We are 25K away from that giveaway, man, and I'll catch you on the next one.